This presentation deals with your legal rights regarding Ontario courts. Although much of the information here is directed at Ontario courts, it would also be admissible in many other courts as well. This presentation is brought to you by Denied Truth. Do police have jurisdiction to enter private property? The truth of the matter is, police, at least the Ontario Provincial Police, and as well as the local police, usually employed by a municipality, have no jurisdiction in civil matters. They can enter private property if there's a criminal offense. Otherwise, they are there to maintain the peace. It's clearly shown here based on a Google search. It's also within the Police Act, and it was confirmed by senior police officers when I spoke with them previously. Are court cases to be held in public? Yes. Many courts are now conducting probably all of their cases by way of Zoom or some other platform. But Section 135 of the Courts of Justice Act clearly states that all court cases are to be held in public. So this begs the question, why are they conducting cases in private? Well, clearly they have something to hide. Can you record your own court case? Yes. In Ontario, Section 136 sub 2b of the Courts of Justice Act gives every citizen in Ontario or their solicitor the right to record their own court case, provided you do it unobtrusively. This is beneficial because the court will tell you that you do not have the right to record your own court case. The truth is you do, and unless the court has something to hide, they would have no objection to you doing it, provided you weren't disrupting the court in the process. I have contacted the Ontario Superior Court and requested an audio transcript of a hearing to which I was involved in. And it took them over 7 months to provide this document, and I had to threaten them legally in order to obtain it. Legally, they are supposed to provide this document, or this audio file in this case, within 30 days. So this begs the question, why did it take them 7 months and threats of legal action in order to get them to produce it, which they previously advised they did not record? This now is fraud on the court, by the court, which means the court lost permanent jurisdiction. Clearly states here under Section 136, there's an exception to the rule. Okay? Nothing in Section 1 above prohibits a person from unobtrusively making handwritten notes, sketches of a court hearing, or prohibits a lawyer or party acting in person or a journalist from unobtrusively making an audio recording of a court hearing in a matter that has been approved by the judge. Well, you don't need the judge's approval, because it says under exceptions, under subsection 1, does not apply to photograph, motion pictures, audio recordings, or records made with the authorization of the judge. But then it goes on further to say that a person can do this if it's for their own case. I've also had the court seal documents or tell me I need a court order to obtain them, and they were documents that I filed in court. I am allowed, as is anyone, upon payment of a prescribed fee, a person is entitled to see any document filed in a civil proceeding in a court, and they could ask for photocopies of certain documents or maybe the entire document. So why did the court mislead me and tell me that they required a judgment from a judge? I had to apply to the court. Again, the court is committing fraud to seal or conceal evidence. Can a court seal a case without cause? No. There are certain exceptions when a court may seal a case, such as if it was going to disclose proprietary information, if it was a matter of national security, or if they had to protect the identity of, say, a witness protection person or a young offender, and in family cases. Otherwise, as shown here, the general rule is a court case cannot be sealed without a darn good reason. Can a court limit your response? No. If a court tries to tell you you only have 20 minutes to present your argument or your defense, and you have quite a lengthy defense or quite a lengthy argument, to limit you and try to rush you through a proceeding is depriving you of due process of the law, which is another common act of many courts. Such action is actually depriving you of due process of the law and renders the case basically void. Is hearsay evidence admissible in court? Generally, no. Now, there are exceptions to the rule. However, what you would like to do, if you're either the plaintiff or the defendant in that case, is prove that the evidence that they want to rely on is non-credible. For example, in a property standards case, let's just hypothetically state that the bylaw enforcement officer stated that you were threatening them. But this information is incorrect. You've never threatened them, you've never spoken with them in person, other than maybe one time when the police come to your property, and you ask, where's the proof of the threat? Of course, they can't prove it because you didn't do it. And then they want to rely on, say, that same person's information in a hearing. Well, you've proven that person is non-credible. So that comes under perjury. Now, if a lawyer relies on this information, or any information from a non-credible witness, and makes a statement or files an affidavit or another court document based on that information, the lawyer is also now subject to hearsay, and the evidence was provided by a non-credible witness, which is an act of perjury, even if it was on a separate occasion for a separate reason, wouldn't matter. The hearsay evidence rule, you could argue and say, no, the information that they're relying on is based on a non-credible witness which has committed perjury. Is perjury permitted in court? No. Under no circumstances is perjury permitted in court. This is the intentional act of swearing or making a false statement, and is usually done under oath. But in any event, a lie is a lie. Whether it's spoken or in writing, it's a criminal offense, and judges are not permitted to allow such actions. If a judge does allow perjury in court, once it's been pointed out, the judge is just as guilty as the party who made that false statement. Under Section 132 of the Criminal Code of Canada, everyone who commits perjury is guilty of an indictable offense and liable to imprisonment for a term not exceeding 14 years. I have seen in Ontario Superior Court judges allowing acts of perjury despite the fact that it's been pointed out. Therefore, the judge is just as guilty. Under these circumstances, because a judge is now aiding and abetting a criminal activity, the court has basically committed fraud on the court by the court. As such, the findings of that court are inadmissible. The court is required to follow various statutes. The Criminal Code of Canada is a federal statute, so every court in Canada is obligated to at least follow the federal court. But in the Superior Court, there's also the Courts of Justice Act and the Evidence Act, as well as many other acts. The Evidence Act does not permit perjury under any circumstances. I would like to thank the viewers for listening to this presentation, and it's a brief overview of your legal rights in Ontario courts. The information presented here is only a brief overview, but will apply to many other courts irregardless of the place and or country. However, the applicable laws will change with the location. I would like to draw your attention to an email address, deniedtruth@yahoo.com, where you can submit your questions, and also to the Denied Truth Telegram group, which has been created to address many legal issues irregardless of where you are. And it is hoped that the information presented will shine some light on your legal rights regarding the court, because many courts will tell you you do not have the right to record a court case, or you do not have the right to object to something, or they will allow perjury or some other illegal act. And this is done for one reason. The courts get their authority under primary legislation and the statute, and they have an oath to the Crown. They have an oath to the law society they represent, long before they have an oath to you or anyone else. However, many times a municipality or big company will hire some high-priced lawyer, and they will try to snowball the self-litigant. Well, because the self-litigant doesn't know the law, many times their rights get trampled. Now, because the court system and the lawyers take an oath to the Crown and then to the Law Society and are bound by the statutes, more than likely you will not get a fair trial unless you do it yourself. And even at that point, you may not get a fair trial, because the conflict of interest, given the fact that the judges pay as well as the lawyers pay, all rely on running you through the court system, as I call the meat grinder. If you do not know your rights, you will lose them. It is my suggestion that anyone involved in any court case for any legal matter download the applicable statutes relevant to your case and become very familiar with your legal rights regarding the court and your legal arguments, which are expressed within the statutes and or primary legislation. I have provided seminars or webinars, presentations, which will go over some of these legal rights. And they are presented on YouTube and also on Rumble, and will be expressed under the Denied Truth Telegram group as well. It is my hope that the information presented here was useful and helpful to at least some people regarding their legal rights, and it is my hope that everyone takes the initiative to follow the guidelines presented here and the ones presented in my other presentations, and together we can assert our legal rights, which are systematically being taken away by the local government, irregardless of where you are. I have addressed legal maxims, I have addressed the ULEZ cities, I have addressed property standards issues in Ontario and property tax issues in Ontario, as well as this brief overview presented here. I will be addressing additional topics as time permits. I thank you for your time listening to this presentation. Have a wonderful day.